This podcast contains content generated or significantly edited using artificial intelligence tools. All information is provided for general informational purposes only and reflects knowledge available at the time of publication. It does not constitute financial, investment, or legal advice. We recommend that listeners verify the information independently and consult with qualified professionals for personalized advice. Welcome to the Luxembourg Fundcast. Today we're doing a deep dive, really getting into the weeds on something fundamental here in Luxembourg's financial world: legal opinions.
Yes, and we're looking specifically at, the liability side and who actually gets to rely on these documents. We want to break down what they are, why they're so critical for big transactions, the risks involved, and sort of demystify the terminology for you.
Right, because legal opinion might sound a bit dry, maybe technical, but when you see how they underpin major deals, think fund finance, big M&A, capital markets work, they're actually, pretty fascinating. They're kind of the legal scaffolding.
Exactly. And look, for anyone touching Luxembourg finance or law, this isn't just theoretical stuff. Understanding how these opinions work, who gives them, who relies on them, it's essential for navigating the whole system here. It's about the architecture, like you said.
Okay, so let's start right at the beginning. What is a Luxembourg legal opinion? Who, why, where?
Okay, so basically it's a formal professional judgment. A qualified Luxembourg law firm gives you its reasoned opinion on specific legal questions, always under Luxembourg law. It's based on their expertise, their review, but and this is crucial up front. It is not an insurance policy. That's a common misconception. It provides comfort, yes, a professional assessment, but it's not a guarantee against every possible legal issue down the road.
Got it. So the lawyer's considered view on specific legal points in a deal, and the opinion giver, that's always a Luxembourg law firm, registered with the Barreau, the Luxembourg Bar Association.
Correct. The firm itself takes responsibility. Usually a partner signs off. But the detailed work, the analysis that's done by their qualified lawyers, the avocats à la cour, as they're known here.
And you mentioned avocats à la cour. What about lawyers working inside companies, juristes d'entreprise? Can they issue these?
No. They generally can't issue these types of opinions intended for third-party reliance. The key reasons are independence and the specific professional secrecy rules that apply to avocats à la cour in private practice. It maintains that external objective viewpoint.
Right, that makes sense. So the law firm gives the opinion. Who asks for it? Who kicks things off?
That would be the client or the opinion requester. That's the party engaging the firm, signing the engagement letter, paying the fees. It could be, say, the borrower in a loan, or maybe a fund setting up a credit line, or a company involved in a merger.
And who actually benefits? Who gets to rely on this judgment? Is it only the client who paid?
Not always. Often there's another key party, the addressee or opinion recipient. This is the party or parties explicitly named in the opinion itself as being allowed to rely on it.
Okay, so like in a loan deal with multiple banks.
Exactly. The borrower might be the client hiring the lawyer, but the whole group, the syndicate of lenders, they'll typically be named as the addressees who can rely on that opinion.
Why is this step so crucial? Why not just rely on the main deal documents?
It really comes down to managing risk in the transaction. The other parties, like those lenders, need independent confirmation from a legal expert that the Luxembourg aspects of the deal are sound. Is the company properly set up and legally existing? Does it have the power and the internal approvals to sign the documents? Are those documents actually legally binding under Luxembourg law? Often, getting this opinion is what we call a condition precedent. Meaning the deal literally cannot close, cannot become final until that opinion is delivered and satisfactory. It's a non-negotiable checkpoint.
And it's always strictly about Luxembourg law.
Absolutely. Yeah. Every single opinion will have a very clear statement limiting its scope. It applies only to the laws of the Grand Duchy of Luxembourg, as they stand and are interpreted by the courts here on the specific date the opinion is issued. It's like a snapshot in time for one specific jurisdiction.
Okay. So for anyone listening, if you're involved in transactions touching Luxembourg, maybe financing, M&A, fund structuring, understanding who issues these, who gets to rely on them, and why they're needed, that's really step one to navigating the deal, isn't it?
It absolutely is. Now, shall we move on to maybe the most critical part? What happens if the opinion, turns out to be wrong? This gets us into the legal framework for liability.
Ah, yes, liability. And this is interesting because Luxembourg law being civil law based, it has two distinct tracks for claiming damages, right?
Yeah, the dual track system, is all rooted in the civil code and sets out who can sue whom On what basis, and importantly, what they need to prove.
Okay, let's take the first track. Contractual liability. Responsabilité contractuelle.
Right. This comes up if there's a breach of the contract between the law firm and its client. That's usually the engagement letter. The guiding principle is pacta sunt servanda agreements must be kept. You'll find this based on Article 1134 of the Civil Code.
So under this track, it's only the client, the one who hired the lawyer, who can make a claim.
Generally, yes. That's the party to the contract. And traditionally, under Article 1150 of the Civil Code, the damages they can recover are limited. It's typically only damages that were foreseen or which could have been foreseen when the contract was made.
So there's a kind of built-in cap.
Usually, yes, unless, and this is a big unless, there was dull. That's a term for willful misconduct, essentially fraud or intentional wrongdoing. If dull is proven, that limitation on damages can be lifted.
Okay, that's the contract pass. What's the second track? Tortious liability.
Tortious.
Responsabilité délictuelle or extracontractuelle.
Exactly. This applies to those non-client third parties we talked about, the addressees. It's not based on a specific contract breach, but on breaching a general duty of care owed to others. Articles 1382 and 1383 of the Civil Code cover this. Basically, if your fault causes damage to someone else, you have to compensate them.
Right. So this is the potential route for those lenders in the syndicate, the ones named in the opinion but who didn't directly hire the law firm.
Precisely. It's the legal door that allows parties who relied on the opinion, provided that reliance was foreseeable, to potentially claim damages if the opinion was faulty and caused them loss.
And there's a key principle here, isn't there? The non-cumulative responsabilité.
Ah, yes, the no accumulation principle. It's fundamental in Luxembourg law. It means there's a strict separation. The client, who has a contract, can't just decide to sue in tort because maybe the rules seem more favorable. They're generally stuck with the contractual route.
And this forces third parties.
It effectively pushes third parties, the non-contracting parties, into the tort framework. And that framework, well, it often has higher hurdles to clear.
Hurdles indeed. For a third party to win a tort claim based on a faulty legal opinion, they need to prove three distinct things, correct?
Yes, absolutely. They need to establish all three pillars, as they're often called. First, they must prove fault, or faute.
Is any mistake a fault?
Not just any error, no. Or simply a different legal interpretation. It generally needs to be a significant professional failing. Sometimes it's described as a faute d'échappement de fonction, a fault so serious it's almost separate from the normal job. The benchmark is whether the lawyer failed to act as a reasonably prudent professional would have in the same situation.
And this often gets equated to faute lourde, gross negligence.
That's right. Luxembourg courts often look for the equivalent of gross negligence. Faute lourde, how is that defined? Think carelessness and lack of skill. Incurie et impéritie is the French term often used. It implies a flagrant disregard for professional duties.
Can you give an example?
Sure, like giving an opinion on a really complex, fast-moving area of law without doing proper research. Or maybe ignoring clear facts provided to them that directly contradict what the opinion says. It's more than just overlooking something minor. It's a serious lapse.
Okay, a high bar. What's the second pillar?
Second, they must prove prejudice or prejudice. This means demonstrating actual, direct, quantifiable financial loss. Speculative damages or what-ifs usually aren't enough. It has to be a concrete loss.
And the third?
The causal link, latent causal. This is often the toughest one. You need to show a direct and certain link between that specific fault by the lawyer and the financial loss you suffered.
How do you show that?
Well, you have to demonstrate that you actually relied on the incorrect part of the opinion, that your reliance was reasonable under the circumstances, and crucially, that but for relying on that faulty opinion, you wouldn't have suffered the loss. Maybe you wouldn't have done the deal at all, or you would have structured it differently. Proving that but-for element can be very difficult in complex deals where lots of factors influence decisions.
Wow. So understanding those three fault, prejudice, causal link is really key. It shows the burden of proof is significant, especially for third parties relying on the opinion.
It absolutely is. And because the potential liability is significant, lawyers use specific tools within the opinion itself to manage and, well, limit that risk.
Ah, right. The fine print, so to speak, the assumptions, qualifications, and those liability caps.
Exactly. These are standard features, and they're all about allocating risk. Let's start with assumptions.
These are things the lawyer just assumes are true without checking themselves.
Pretty much. They're explicitly listed points the lawyer takes as given. Common ones include assuming signatures are genuine, copies are accurate, information from public registers or certificates is correct. Also assuming that parties from other countries have the necessary power under their laws, that the deal documents reflect the commercial agreement, and often that the client isn't insolvent and the deal has a legitimate purpose. No money laundering, for instance. By listing these, the lawyer is essentially saying, my opinion holds if these things are true. I haven't verified them. That risk is on you, the recipient.
Okay, that makes sense. Then you have qualifications and exclusions.
Right. These carve out specific areas the opinion doesn't cover. It might explicitly exclude matters of pure fact or financial and accounting judgments. Often specific areas of law are excluded too, like tax, competition law, environmental law, IP, unless, of course, the lawyer was specifically asked to opine on those points.
You also mentioned qualifications about enforceability.
Yes, very important. Opinions nearly always state that even if a contract term seems valid, its enforceability might be limited by general principles of Luxembourg law. Think about how courts might reduce excessive penalty clauses, or rules around compound interest, or the legal uncertainties around enforcing certain subordination clauses, especially if a company goes bankrupt.
So these qualifications flag areas where the law itself might step in, regardless of what the contract says.
Exactly. They highlight inherent legal limitations or areas of uncertainty, managing the lawyer's risk by making the recipient aware of them.
Okay, now let's talk contractual liability caps. This is where the lawyer tries to put a ceiling on the potential damages owed to their client.
Yes, it's common practice. Clauses limiting the maximum payout, maybe a multiple of the fee, or a fixed sum in euros, are generally valid between the lawyer and the client who hired them, based on that Article 1134 principle of contractual freedom.
But we talked about that major exception earlier, faute dolosive.
Ah, yes, the crucial point. If the client's loss is caused by the lawyer's faute dolosive, which, remember, Luxembourg courts often equate with gross negligence, that incurie et impiété, the flagrant disregard for duties,
Then the cap.
then the liability cap is completely void, unenforceable. It simply doesn't apply if the lawyer is found to have been grossly negligent in causing the loss.
Wow. So that negotiated limit can just vanish based on the quality of the work. That really underscores why the due diligence and drafting have to be so careful. It's not just about looking good, it's fundamental risk protection for the lawyer.
Absolutely. The fee reflects not just time, but also this significant, potentially uncapped risk they take on if things go badly wrong due to their own serious feelings.
What about those caps applying to third parties, the addressees suing in tort?
That's complicated and evolving. The traditional view was a third party isn't bound by a contract limit they never agreed to. Makes sense, right? However, there's a developing line of thought influenced by modern French case law, which often informs Luxembourg law, suggesting that if a third party chooses to rely on the lawyer's work product, the opinion, which itself arises from that contract, maybe they should be subject to the limitations within that contract, including the cap. It's definitely not settled law here, but it's a live issue, a point of real debate.
So the potential for gross negligence to nullify the cap, plus this uncertainty around third parties, it really highlights the stakes involved, explains why these opinions aren't cheap.
Very much so. Now, all this risk and legal judgment gets packaged into a very specific document format. There's a whole process behind it.
Right, let's look at the anatomy of the opinion itself and how you actually get one issued. It sounds like a very structured document and a collaborative process.
Definitely structured, and yes, collaborative between the lawyers, the client, and often the lawyers for the addressees.
So walk us through the typical sections. What's in the anatomy?
Okay, it usually starts with scope and addressees. This sets remember, the snapshot idea. It clearly identifies the transaction, names the specific parties allowed to rely on it, the addressees, lists the exact documents the lawyer reviewed.
And the Luxembourg law limit.
Yes, and that critical statement that it's only about Luxembourg law as of that date. Plus, usually, a disclaimer saying they have no duty to update it later if laws or facts change.
Then come the sections we just discussed, assumptions and qualifications and exclusions.
Correct. Listing what's assumed true and what's explicitly not covered.
And the core, the actual legal conclusions.
That's the operative opinion section. This is the heart of it. In typical finance or M&A context, you'll see opinions on things like due incorporation and existence, confirming the company is properly registered and active, usually checked against the LBR, the Luxembourg Business Register, and its articles. Corporate power, meaning the company has the legal capacity under its own rules to do the deal. Due authorization confirming the necessary board or shareholder approvals were properly obtained. Due execution that the people signing had the authority to sign. And then, usually the most heavily negotiated one, valid and binding obligations.
Meaning the core deal documents are legally enforceable.
Yes, but always with standard caveats. That opinion is almost always subject to general principles of law, like the effects of bankruptcy, insolvency rules, principles of equity, and other general limitations on creditors' rights.
Got it. And the last part usually controls who gets to see it, reliance and disclosure.
Exactly. This clause hammers home that reliance is strictly limited to those named addressees, only for this specific transaction, and it forbids sharing or circulating the opinion without the lawyer's express written consent beforehand. This ties back to the lawyer's duty of professional secrecy, which is a strong principle here.
Okay, that's the document. What about the process? How does it happen in practice?
It's usually several phases running alongside the main deal. Starts with engagement and scoping, agreeing what needs to be covered. Then there's significant due diligence.
Reviewing company records, deal drafts.
All of that. And often relying on an officer's certificate. This is key. It's a formal statement from a director of the client company confirming certain facts the lawyer can't easily verify independently, like maybe solvency, or that provided document copies are complete and accurate. The lawyer states they're relying on the certificate.
And then comes the negotiation phase. Sounds like where the arguments happen?
Well, maybe detailed discussions is better. The lawyer drafts the opinion, shares it with the client and the addressee's lawyers. It's fundamentally about risk allocation. The lawyer wants clear boundaries. The recipient wants broad comfort. They'll negotiate the precise wording of opinions, the scope of assumptions and qualifications, the liability cap amount, and exactly who gets named as an addressee.
And finally, finalization and delivery.
Yes. This usually happens right at the closing of the main transaction. The opinion is dated for the closing date, refers to the final signed documents, and is delivered as one of those conditions precedent we mentioned.
Timeline and cost. Rough estimates.
Timeline really depends. Weeks for something simple, months potentially for a highly complex international deal. It tracks the main transaction. Costs. There's no official tariff. It's privately negotiated, usually based on hourly rates, though fee estimates or caps are common. Bar guidelines mention factors like the deal's importance, the liability assumed, complexity, time spent, lawyer experience, and client means. You'll typically see professional fees plus disbursements or overheads, maybe 5 to 10%, plus VAT at 17%.
Okay, so understanding the structure helps you read an opinion critically,
Yeah.
and knowing the process helps understand the resources and negotiation involved.
Precisely. And remember, this all happens within a wider market context. It's not just about the civil code anymore.
You mean like regulatory influences? We noted that the CSSF, the Commission de Surveillance du Secteur Financier, and the Luxembourg Stock Exchange create sort of de facto regulatory standards.
That's a really important point. They don't write rules for opinion drafting, but their rules for the banks, funds, and companies they supervise indirectly shape the diligence lawyers need to do.
How so?
Well, say a lawyer is opining that a regulated fund has the corporate power to enter a major outsourcing deal. The lawyer can't just look at the fund's articles. They implicitly need to consider if that deal complies with detailed CSSF circulars on outsourcing, like Circular 22806, or internal governance like 12552.
Or for listings on the stock exchange.
Right. If a company is listing securities, the lawyer's diligence might need to cover compliance with the Luxie's specific rules, perhaps enhanced AML KYC requirements. Or now, for DLT securities on the SOL platform, the securities official list, the Luxie, might require a specific legal opinion confirming their status. DLT means distributed ledger technology, by the way.
So the law that the opinion effectively covers is much broader now. It includes this whole layer of financial regulation.
Absolutely. It makes the diligence far more complex, especially in finance, and definitely adds to the risk and cost involved in giving these opinions.
What about emerging trends? Is the landscape changing?
Constantly. Luxembourg got a new constitution just last July, 2023. There's talk of potentially overhauling the law of obligations, maybe following France's lead, and recent laws on things like right of establishment or labor law can affect the companies we give opinions on.
And technology, DLT, crypto.
Huge impact. How do you legally classify these new digital assets? Giving opinions in transactions involving them requires very specialized knowledge. And look at DORA, the EU's Digital Operational Resilience Act.
What's that?
It sets new EU-wide rules for managing ICT risk in financial services, applying from early 2025. Lawyers involved in relevant deals will need to consider its implications in their diligence.
And more regulation generally.
Seems inevitable. The new EU AML package will likely mean even stricter checks. The CSSF is also focusing heavily on things like greenwashing risks and compliance with SFDR, the Sustainable Finance Disclosure Regulation.
So the picture for legal opinions here is one of growing complexity, increasing specialization needed, driven by both tech and regulation.
I think that's fair to say. The need for that careful, expert judgment to manage transaction risk is definitely not going away, and the environment keeps getting more challenging.
Okay, so we've covered a lot of ground today. We started with what a Luxembourg legal opinion actually is, who's involved, the giver, the client, the addressee. We looked at that dual liability system under the civil code, contractual versus tortious, and the hurdles for third parties' fault, prejudice, causal link.
And the tools lawyers use to manage risk assumptions, qualifications, those crucial liability caps, and the faute dolosive exception.
Right. We walk through the typical structure of the opinion document, the practical process of getting one issued, and the cost factors. And finally, we touched on how the wider context, CSSF and Luxembourg rules, new tech like DLT, and ongoing legal and regulatory changes is shaping how these opinions work.
They really are indispensable tools for navigating complex deals here, providing essential assurance based on, well, rigorous legal work and diligence.
So here's a final thought for you to consider. As finance keeps evolving, think DLT, AI, tightening regulations, how will these core principles of legal opinions, especially around risk allocation between the lawyers and the people relying on their work, continue to adapt? How might future court cases test these boundaries? Definitely something to keep in mind if you're operating in this space. This podcast contains content generated or significantly edited using artificial intelligence tools. All information is provided for general informational purposes only and reflects knowledge available at the time of publication. It does not constitute financial, investment, or legal advice. We recommend that listeners verify the information independently and consult with qualified professionals for personalized advice. Hit that like and subscribe button. It was the Luxembourg Fundcast for you today.